Welcome to the Citizenship Clause of the 14th Amendment, Historical Foundations and Modern Misinterpretations by the Grumpy Old Vet. This video explores the historical, legislative, and judicial foundations of the Citizenship Clause in the 14th Amendment of the United States Constitution. It critically examines the modern interpretation that grants automatic birthright citizenship to the children of illegal immigrants, and the expanded application of the Due Process Clause to confer Article 3 court protections to individuals unlawfully present in the United States. Through a review of congressional debates, judicial decisions, and constitutional theory, this paper presents an argument that the original intent and structure of the 14th Amendment have been distorted to serve contemporary political agendas. 1. Introduction. Understanding the Citizenship Clause. The 14th Amendment, ratified in 1868, was a response to the legal and political aftermath of the Civil War. Its Citizenship Clause reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." While this clause is now often cited to justify automatic citizenship for all born on U.S. soil, including children of illegal immigrants, such an interpretation is historically and legally contestable. This paper argues that the modern expansion of the citizenship and due process clauses departs from the amendment's original meaning and undermines both the rule of law and the sovereignty of the states. 2. Historical context and legislative intent, origins and meaning. The 14th Amendment was drafted in response to the Supreme Court's decision in Dred Scott v. Sanford, 1857, which held that African Americans, whether enslaved or free, could not be citizens. In response, Congress passed the Civil Rights Act of 1866, which granted citizenship to all persons born in the United States and not subject to any foreign power. This phrase was critical and was later echoed in the 14th Amendment. Senator Jacob Howard, who introduced the Citizenship Clause in the Senate, clarified its intent by stating that it would not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers. This statement is central to the argument that the clause was never meant to extend citizenship to those not fully subject to U.S. jurisdiction, i.e., those who owe allegiance to another sovereign, including those unlawfully present. 3. Judicial precedent. United States v. Wong Kim Ark. The modern doctrine of birthright citizenship largely rests on United States v. Wong Kim Ark, 1898, in which the Supreme Court ruled that a child born in the U.S. to Chinese parents who were lawful residents but not citizens was a citizen under the 14th Amendment. However, the decision explicitly did not address the status of children born to those unlawfully present. Critics argue that Wong Kim Ark has been misapplied to suggest a blanket right to citizenship regardless of the legal status of the parents. The opinion's reliance on jus soli, the common law principle of birthplace citizenship, must be balanced against the jurisdictional qualifier in the constitutional text. That qualifier, subject to the jurisdiction thereof, cannot be interpreted as mere physical presence. 4. Due process and jurisdictional overreach, judicial and practical implications. In addition to the Citizenship Clause, the 14th Amendment's Due Process Clause has been invoked to argue that illegal immigrants are entitled to Article 3 court protections and full constitutional rights. This development has blurred the lines between legal and illegal presence, citizenship, and alienage. Traditionally, Article 2 immigration courts, part of the executive branch, have handled deportation proceedings, asylum claims, and other administrative immigration matters. These courts are not judicial in the Article 3 sense. They operate under the plenary power of Congress and the executive authority of the President. They provide procedural safeguards but are not designed for the full panoply of constitutional protections afforded in Article 3 courts. However, due to expanding interpretations of the Due Process Clause, Some activist judges have attempted to extend Article 3 jurisdiction to illegal aliens. This includes challenges to deportations, detention conditions, and constitutional claims by individuals who are not lawfully present in the United States. The result has been a costly and time-consuming reallocation of judicial resources. The burden is immense. Conservative estimates suggest that over 6 million individuals have been allowed to enter and remain in the country unlawfully in recent years due to administrative inaction or refusal to enforce immigration law. If each of those individuals were to be processed through Article 3 courts, it would require thousands of new judges, billions in funding, and decades of litigation to resolve existing cases. This burden not only strains the justice system, but threatens to normalize the treatment of illegal entrants as if they were lawful citizens. Compounding this issue is the philosophical confusion between illegal entrants, lawful residents, and agents provocateurs. Under the Alien Enemies Act of 1798, the federal government retained explicit authority to detain or deport individuals deemed to be hostile foreign agents. This distinction is important. While the Constitution guarantees due process, it does not guarantee uniform treatment to those in violation of immigration law or those seeking to subvert national security. Yet current judicial practice often fails to make these distinctions clear. 5. Dual sovereignty and constitutional authority, federalism and citizenship. The framers of the 14th Amendment understood citizenship as not only a legal status, but a political allegiance. The dual sovereignty structure of the Constitution reserves substantial power to the states, including the ability to set and enforce laws governing their populations. Broadening the interpretation of the Citizenship Clause to include those in violation of immigration law compromises state sovereignty and national integrity. 6. Modern political agendas, distorting the 14th Amendment. The contemporary interpretation of the 14th Amendment is often advanced not on originalist grounds, but on ideological and political ones. Birthright citizenship for the children of illegal immigrants serves globalist objectives, dissolving borders, diluting national identity, and undermining local authority. Similarly, extending full due process rights to illegal aliens places additional burdens on the judicial system and erodes the distinction between citizen and non-citizen. 7. Conclusion: restoring constitutional order. The 14th Amendment was a corrective to a specific injustice, the denial of citizenship to freed slaves. It was not a blank check for open-ended birthright citizenship, nor a backdoor to Article 3 court access for illegal aliens. A faithful reading of the text, informed by the original debates and subsequent legal interpretations, supports a more limited and constitutionally grounded view. To restore constitutional order and national sovereignty, courts and policymakers must return to the true meaning of the Citizenship Clause and resist the political temptation to expand its reach beyond recognition. References: U.S. Constitution Amendment 14, Civil Rights Act of 1866, Dred Scott v. Sanford, 60 U.S. 19 Howe, 393, 1857, United States v. Wong Kim Ark, 169, U.S. 649, 1898, Prince v. United States, 521 U.S. 898, 1997, 32 U.S. Code subsection 109, Congressional Globe, 39th Congress, First Session, 1866, Howard, Jacob, Senate Debate, May 30th, 1866. American Mind, The Citizenship Clause Debate, Heritage Foundation, Legal Memoranda on Immigration Jurisdiction, Alien Enemies Act of 1798.